transfer to the child, the house would transfer subject to the mortgage. And there is a federal law that actually prohibits the lender on that mortgage from calling the loan.
Interesting. Okay. So if they have like a $300,000 mortgage or a $50,000 mortgage, it can be excluded from that then. Okay. Interesting. So can a creditor take the money in your bank account? Yes or no? Or is that more involved too?
So for a creditor to take money in your bank account, is it possible? Yes. But a creditor would need to sue you, obtain a judgment in court, and then it would need to enforce its judgment. So it has a certain time period in which to file the lawsuit. And then once the judgment is obtained, in which to obtain to garnish the wages or the bank account, it's usually a long period of time. It can be 20 years.
Oh,
so
okay.
Creditors can, once they get their judgment, enforce their judgment, but they do have to take some proactive steps in order to do that.
Mm-hmm. So how could someone protect the bank account from creditors? Are there certain things that they could do before they pass away?
Well, if they have a bank account that they want to protect from creditors, as I mentioned earlier, they could have created the Domestic Asset Protection Trust, the DAPT. That's called a self-settled trust, where you put your assets, like a bank account, into an irrevocable trust for your benefit and the benefit of others, so long as you don't have creditors when you created the trust and you're not attempting to defraud creditors. And in that case, you've protected them because they're in an irrevocable trust, but you also need to have some special magic language in your trust that restricts your access to the funds in a way that doesn't allow the creditor to come in and say, well, you have unrestricted access to the funds, so I should therefore get it because you owe me money. So irrevocable trusts are created in a way that the person that's the beneficiary does not have unfettered access to the money. It can be created flexibly so that the trustee of that trust can make distributions to or on behalf of the beneficiary, and therefore the beneficiary has access to the funds and therefore can have their needs met. But at the same time, the creditor can't step in and say, hey, give me all this money since you're a beneficiary of a trust.
Okay, that makes sense. Yeah, but so what is this HEMS standard, HEMS standard I've heard about? Can you talk a little bit about what that means for a child or the parent? In other words, how does it work?
Sure. So when you have this irrevocable trust, and let's say you set up an irrevocable trust for a child, you say, at my death, pay the assets of my estate or my trust into an irrevocable trust for my child. And I want my child to actually be the trustee of that trust. Well, in order to prevent a creditor from saying, hey, you're the trustee and a beneficiary child, so give me that money because you owe me money, the trust has to have special language that creates what's called a HEMS standard or an ascertainable standard. HEMS stands for health, education, maintenance, and support. And maintenance and support are synonymous. A HEMS standard causes the assets to not be includable in the child's estate because of that language, that restriction. And by the way, HEMS covers most of someone's needs. So for example, if a child is trustee and beneficiary, the child can distribute to himself or herself for groceries, for a mortgage payment or a rent payment, for normal vacations, for all of the child's living needs that are, for their support and their maintenance. The trust can provide for it, and the trustee, even if it's the beneficiary, can provide that to themselves. But to the extent that you exceed a HEMS standard, okay, so for extraordinary distributions, then you have a problem because the creditor could come in and say, whoa, if you have unfettered access, then I can take this money to pay the debts that you owe me. And so in that case, oftentimes what we do in our trust is we provide for a disinterested trustee, one who is not a beneficiary, who can make distributions in excess of HEMS. If you have a child, for example, who wants to buy a house, And there's two ways that the child can get money to do it. One, the child's the beneficiary and the trustee of his or her own trust. He can make a distribution to himself or herself of $200,000, let's say, for a down payment. Well, he probably can't make that distribution because that's an excess of maintenance and support. You don't need a $200,000 distribution for your maintenance. You need a monthly rent payment or a monthly mortgage payment. And so in that case, the child would want a disinterested trustee to allow for this extraordinary distribution to make a down payment on a house in the child's own name, because the assets are then leaving the trust. Alternatively, if the child is the beneficiary and the trustee, perhaps the child could actually invest the trust assets in a home titled in the name of the trust. And then the child can live in that home, which rent-free, because the child's a beneficiary, and that's like its normal monthly mortgage payment or its normal monthly rental payment. And so you can essentially have the home protected from the child's creditors by being titled in the name of the trust. And the child doesn't even need to rely on a disinterested trustee in order to do that, because they're not making a distribution out of the trust. It stays in the trust and therefore protected. And frankly, the best place we see this happen is when a child is the beneficiary and a trustee of a trust, and they're going through a bad divorce, a divorce that's not amicable. Because inherited assets are separate property. They're not subject to division upon divorce. And so if the child is able to buy the house in the name of the trust, even if they live there together as a married couple, then the child, upon divorce, still has the ability to live in the house because the child's, trust owns that house. And then the divorcing spouse is actually the one that needs to move out.
Well, that sounds like a good, safe bet to do that. So it really doesn't make sense to put assets in your children's names, does it? What are some of the pitfalls with that?
There are so many. First, I see this all the time. Clients will come in, let's say they have 3 kids or 2 kids. They come in and they say, well, my child who's local is the one that helps me. And so I put him or her on my bank account, or I put him or her on my deed because I don't want the child to have to deal with probate when I die. And every time this happens, I have to advise clients about how to undo what they've done, because they've essentially made a gift either at that time or in the future to the child that they probably didn't want to make. So most clients want to leave their assets in equal shares among their, children. And when you put someone else on title, for example, on a deed, then that is an immediate gift of 1/2 of the property. And a gift tax return is required to be filed. And of course, nobody does, because they don't realize that they've basically caused an immediate gift for which they have to file something. And it's also bad tax planning, because frankly, when you put a child on a deed, you're giving the child your basis in the property. Your basis is the amount that you paid for the property plus any improvements. And a lot of times what I see is clients have bought property 30 years ago, and there's a huge inherent gain in that property, and they've just been holding onto the property, and they intend to die with the property. And if they had just died with the property, they would have gotten a new basis equivalent to the fair market value for their kids at that time. But by giving a child 1/2 of the property, by putting them on the deed, they've essentially given the child 1/2 of their current basis, which is, the low basis from 30 years ago. I also see parents putting a child on bank accounts frequently. And sometimes these bank accounts are really big bank accounts. And so, for example, they may have a huge checking account with like $200,000 in it, and they put a child on the account to help pay for expenses rather than making the child what is essentially a power of attorney over the account. When you put a child on the account, they become a co-owner as opposed to just an agent under power of attorney. When they become a co-owner, what happens is when you die, if you die first, your child then becomes the full owner of that account outside of probate. And that account is not divided equally among, for example, the 3 children. And the only way to get that money to the 3 children is if the child who inherited that account upon surviving the parent that dies either makes gifts or executes something called a disclaimer. And so it becomes a real problem getting the money to go in the way the parent intended, because by retitling assets and putting a child on title, it really affects where money goes.
Incredible. The things that we really need people like you to advise us, for sure. We just have a few more minutes, but I did want to just have you address what are some legal methods that people can use to protect a child's inheritance from a divorce? And then we'll wrap it up and give people an opportunity to find out how to contact you.
Sure. I think the biggest piece of advice I could probably give to clients about protecting children, especially if they're going to be divorcing or in a rocky marriage, is to leave a child's inheritance in trust. It separates the property as inherited property, so it's not subject to division upon divorce. It is protected from the child's creditors. So there could be work creditors, there could be creditors from an accident that the child is the cause of, and there can be a spouse that's, future spouse that's a creditor. And so leaving the inheritance in trust with the child as trustee or not as trustee, but in trust for the child, protects the child from himself or herself. And, there is a cost to keeping assets in trust because there is a tax return that needs to be filed annually for the trust. But to the extent that the trust owns, for example, $1 million or more of assets, I think the idea of having the trust easily outweighs the administrative costs and burdens of preparing and filing the tax returns.
Well, thank you so much, Michelle. And would you please, for listeners, just include your website and your email address so that people, even if they don't live in DC, Maryland, or Virginia, can write to you and perhaps ask for the name of an attorney in their area. Thank you so much for joining me.
Sure. Thanks for having me. My website is paleyrothman.com, PALEYROTHMAN.com. My email is mchapin@paleyrothman.com. That's MCHAPIN@paleyrothman.com.
Thank you so much, Michelle. And for those of you who are listening, remember it's this one and the previous one on inheriting your parents' assets. And it's just chock full of information that will help you. And thank you so much for joining me, Michelle. I really appreciate it.
Thank you, Debbie, for having me. I really enjoyed it.